What happens when a state prosecutes pornographic movie actors for prostitution because they received pay for their sexual acting in the film? Or what happens when a state restricts drag performances in the event non-adults may see them? What about 2025's Texas age verification requirement to access online pornography? Obscenity. Do you know it when you see it? Hello and welcome. My name is Peter Afrasiabi. We will answer all these questions today. I am an intellectual property litigator at the law firm of One LLP with offices in Newport Beach and Los Angeles, California. My practice focuses on copyright, right of publicity, trademark, and related privacy torts. I also teach as an adjunct at the University of California Irvine School of Law, where I teach a Ninth Circuit Appeals litigation clinic with my students, as well as an advocacy and persuasion course. I have taught advocacy at the National Institute of Trial Advocacy and taught advocacy to new barristers at Oxford University in England. But keep in mind, all of the views expressed in this video are mine and mine alone, and are not the views of my law firm, the university, or any other academic institution or entity I work with. Today's program is on sex, speech, and the First Amendment, stemming from our Curious Lawyer series, and is a look at the intersection of laws related to sexual behavior and how they intersect with the First Amendment. From states regulating pornography movies as acts of prostitution when the performers are paid, to laws about virtual pornography and modern state laws regulating drag performances, you will get a walk through fascinating sex-based laws and the First Amendment. Is it obscene? Do you know it when you see it? This will be educational on the First Amendment and hopefully entertaining as we see our regulatory culture as it relates to sexual conduct. But first and briefly, I want to tell you more about the Curious Lawyer series that we have created for you, a true Curious Lawyer. The Curious Lawyer series is a fun, educational, and entertaining walk down some of the off-the-beaten paths of law, areas that you do not experience in your regular practice day to day, but which are incredibly interesting and informative, and often yield new insights and valuable analogies or metaphors that you can work with in your practice. In this series, we take a variety of interesting issues and intersect them with the law to find fascinating, new, educational, and informative areas of the law to explore, and to better educate you about legal areas you may not know. For example, we have done programs on dog law where you get to think about your favorite furry friend and see how our relationship with dogs intersects the law, from tort to contract law, to even trusts and estate battles over dogs. And, of course, Fourth Amendment cases where there have been warrantless removals of dogs from homes for violating the leash laws. Or you can see the CIA law program where you will see fascinating legal topics related to the CIA, secrecy, and the Freedom of Information Act, and where you will learn about that famous Hollywood movie line, "I can neither confirm nor deny." You will learn where it came from, and it turns out it was not Hollywood, but you have to watch it to learn who came up with it. We have also looked at whether there's a little sliver of Yellowstone National Park, where, due to a combination of the Sixth Amendment's vicinage requirements and the subsequent federal districts that were created by Congress to sit over the nation, whether that, in fact, has actually yielded a sliver of land in our famed Yellowstone that is free from federal criminal prosecution. Is it a perfect crime zone? Listen to that program and you will find out. And if you want to brush up on the Bill of Rights, we have a 10-part series with 1 hour devoted to each of the first 10 amendments to the Constitution, so that you, at the next cocktail party, can answer when a non-lawyer asks you what one of the amendments is all about. The one thing the Curious Lawyer series is not is boring. This is most definitely not your typical continuing education. That is often technical, difficult, or stressful. So sit back and grab a cocktail, if you are so inclined, and let's get going in our fascinating, crazy, and at times exploration of where the First Amendment meets sexual behavior. Here is our overview and agenda of where we are going today. We will do an overview of cultural and legal conflicts over sexual expression and regulations. This takes us to the First Amendment. We will explore why the First Amendment often intersects with sexual-based moral legislation. We will look at key Supreme Court rulings, and we will listen to parts of some of the oral arguments to see the issues as framed and then unpackage the decisions. This takes us to a quick overview of basic First Amendment legal issues on content-based restrictions, government police power to regulate, and how courts assess legal regimes that touch on sexual expression. Do courts use strict scrutiny for sex-based laws that impinge on speech? Or are they moving to a lower form of scrutiny that protects the state police power to regulate speech in the sex context more? As particular cases, we will look at drag show bans and free expression. We will ask questions about whether sexual conduct is prostitution or is it protected expression as a pornography film. We will look at online virtual child pornography restrictions as they collided with the Supreme Court. We will look at cable restrictions on sexually explicit material, and we will look at state regulation of incest as against free expression and due process. And we will look at the most recent 2025 Supreme Court decision on age verification requirements for access to pornography. Let's start with a quick overview of the First Amendment and some older and modern cases to explore state laws restricting speech and expression and how they get tested in courts. You see here we have the case of State versus Gruber. This is from Maryland in 1819, and this involved a Reverend Gruber who was a member of the Methodist Episcopal Church, and he preached a sermon at a camp meeting, and this was organized by his Methodist Episcopal Church, and he preached this sermon to around 5,000 white people who are in attendance and around 400 odd slaves. Now, Reverend Gruber criticized slavery as a, quote, national sin, end quote, and said, "This is contrary to the founding principles of the Republic." In short order, Gruber, Reverend Gruber that is, was arrested and in a criminal indictment. He was charged with attempting to stir up acts of mutiny and rebellion. It's a sort of an old form and essence of incitement, and the incitement speech issues, which have, as we see now, touched the country from the beginning and touch us even to this day. Now, what happened in this case, interestingly, is that a lawyer by the name of Taney, who later became an infamous Supreme Court justice, represented Gruber and secured an actual acquittal in front of the jury on free speech basis. So the case never made its way up to the Supreme Court, but it's an early example of someone engaging in speech that's deemed insightful and likely to cause problems. And also now it's abolitionist speech, obviously, the massive issue of that day in terms of slavery and abolition. But Taney was able to secure an acquittal in front of the jury, saying that the Reverend had the right to engage in that speech by calling slavery an original sin, and that the prosecution was fundamentally improper because he secured an acquittal. Now, what's interesting is that in many southern states, states then started actually passing more specific laws, banning abolitionist literature and speech. And in perhaps great tragic irony, I guess that is the word here perhaps, or just plain tragedy, to the situation this lawyer Taney, who represented Gruber, found himself in. He secured an acquittal of Gruber, allowing him to engage in abolitionist speech. But Taney later, when he was on the Supreme Court, delivered the Supreme Court's infamous Dred Scott decision in 1857. There's an arc across time in our past for you. We're going to look now at a 20th century huge case, and that is Debs versus United States. And this is in 1919. And it'll allow us to look at what is fundamentally incitement speech to explore categorical definitional purposes and categories of speech that can be limited. It's not a prison case, at least not totally. So Debs was obviously a very well-known public figure. He'd received almost 1 million votes when he ran for president in 1912 on the socialist ticket. And then in 1918, Debs gives a speech outside the Canton, Ohio prison, and he'd been there visiting 3 socialists who were convicted of violating the Sedition Act, and they had been imprisoned. Now, the Sedition Act at issue here provides any disloyal, profane, scurrilous, or abusive language about the government of the United States or the flag of the United States or the uniform of the Army or Navy could be prosecuted. So Debs goes out, he speaks to 12,200 people outside this prison. He offers his support for the prisoners, saying they're paying the price for seeking to pave the way for better conditions for all mankind. He was a pacifist. He condemned the war, but he actually took care not to advocate any illegal activity, and even commented to his audience that he had to be prudent with his word choice. Nonetheless, he was arrested and convicted. He got a 10-year sentence, and he takes this up on appeal to the U.S. Supreme Court, arguing that it violated his First Amendment speech rights. And so let's look on the next slide at what had come down in the exact same term. And that's the well-known case of Schneck. And Schneck is a case, of course, that decided and adopted the clear and present danger test for speech looking at words in context. So, as applied to Debs, a unanimous Supreme Court, as written by Justice Holmes, held that even though Debs did not expressly advocate draft resistance, his intent and the general tendency of his words were together sufficient for a jury to convict him fairly. And in fact, and perhaps tragic irony here too, the Supreme Court even noted that, he had noted in his speech that he had to be careful what he said, and that showed an awareness that he was kind of in the zone of incitement, as opposed to seeing it as a sign of him actually being careful. Now, the same term we had Abrams 5 U.S., and this is about 8 months later on where you have a similar case of several individuals who are convicted of distributing leaflets advocating their political views about the Russian Revolution. They were convicted as offering clear and present danger speech. There, where the conviction was affirmed by the Supreme Court, but this time Holmes issued actually an impassioned dissent. And in dissent, he said those who think they are right will find it perfectly logical to translate their convictions into the law and impose them on others. But it is the theory of our Constitution that the best test of truth is a free trade in ideas. So interestingly, he himself dissenting there, saying that didn't have the same feelings towards Eugene Debs several months earlier. But nonetheless, after 3 years in prison, Eugene Debs' sentence was commuted, but it enabled President Harding to be elected. So Debs wasn't around to interfere with the election. Debs illustrates a category of speech that was subject to regulation, speech that poses a clear danger to society, what we today see as incitement-type speech. Another category is obscenity, and that is what we will be looking at as we explore sex and speech. Let's take a little quick sidestep here and talk about whether the First Amendment applies to the states. And this is the incorporation doctrine issue. And so the fundamental issue is that we have this idea that the protections of the constitutional amendments in the Bill of Rights had only applied to the federal government at the founding of the Republic. They did not apply to the state governments. And so the question then was raised after the Civil War amendments were adopted as to whether the 14th Amendment's Due Process Clause fundamentally incorporated those 10 amendments by reference and made them basically applicable to state governments. And this sort of question of whether we had this massive new reordering in our constitutional world after the Civil War amendments is answered by this basic test that the Supreme Court's adopted. And that is, they look to figure out whether the rights at issue in the Bill of Rights are fundamental ones, rooted in the tradition and conscience of our people, and therefore implicit in the concept of ordered liberty. If so, they get incorporated and applied to the states via the 14th Amendment. And that's sort of the test and quote from one of many cases that looks at this test. But the Griswold v. Connecticut case dealing with contraception in the 1960s is one that sort of looks at it. And it's a good case to go look at if you want to get a better sense of the incorporation doctrine. And really all of the Bill of Rights, except a few portions of some of them, have been incorporated and adopted. Now the First Amendment has been. One of the cases is another one of these cases dealing with left-wing manifesto. Here, that was Gitlow v. New York, and there you had state prosecution for a left-wing manifesto publication and conviction. The court held it was incorporated and applied to the states. Let's get our bearings on modern First Amendment principles. The court scrutinizes closely any sort of content-based or viewpoint-based speech restrictions. What is a content-based restriction? This is a restriction on speech that is due to the content of the speech. Here is an example. A law that restricts any type of political message from being expressed in a public place. And these get reviewed under strict scrutiny review, making them very hard to survive. Next, what is a viewpoint-based restriction? This is a restriction on speech that is due to the viewpoint expressed by the speaker. Here is an example. Any law that restricts someone from expressing a specific political viewpoint, such as support for Donald Trump or Barack Obama. Finally, what are content-neutral laws? Laws that restrict speech in a content-neutral manner are generally analyzed under intermediate scrutiny, in that they must serve to advance an important government purpose and must be substantially related to that purpose. One example, an anti-littering law that does not on its face restrict speech, but incidentally does, as a result of its neutral anti-littering application. The question we will ask later today is an age verification law that limits children's access to pornography, materials that is obscene for them, but also limits, as a result, adult access to material that is not obscene for adults. Is that kind of law on sex content subject to strict scrutiny or a lower form of scrutiny? Get ready, as there are sea changes in the law today to see. Let's look at an example of a content-based law and the First Amendment. Here are our facts. In 2005, Gilbert, Arizona adopted a municipal sign ordinance that regulated the manner in which signs could be displayed in public areas. The ordinance imposed stricter limitations on signs advertising religious services than signs that displayed political or ideological messages. A local church would post signs on Sunday about the services in its church. It was then cited for violating the ordinance. The court held that the town sign ordinance imposed content-based restrictions that did not survive strict scrutiny because the ordinance was not narrowly tailored to further a compelling government interest. Justice Thomas's unanimous opinion also clarified that strict scrutiny should always be applied when a law is content-based on its face. So let's dive into sex in the First Amendment. This takes us to a category of speech that can be regulated with more ease. That pure speech, obscenity. In Roth versus United States, the Supreme Court held that obscenity is not protected by the First Amendment. Obscene material is material which deals with sex in a manner appealing to prurient interest. Now, that narrow definition made most pornography legal and enabled the market for now protectable sexual expression works to explode. That is, for pornography to explode. And that required the Supreme Court and federal courts to figure out whether a given movie was obscene and regulatable, or if it fell outside that and thus was lawful expression. This takes us to a pretty hilarious chapter in the Supreme Court's history where it had movie nights to assess these questions. In Jacobellis versus Ohio from 1964, we have the famous Justice Stewart concurrence. Here are the facts. A movie theater owner was arrested and convicted for showing obscene material based upon the French film called The Lovers, which had a sex scene. The Supreme Court reversed this conviction on the basis that the film was protected expression and not obscene. The lasting statement for us is Justice Stewart's concurrence, where he wrote, "But I know it when I see it, and the motion picture involved in this case is not that." This is where the famed "I know it when I see it" standard came from. So in Bob Woodward's book, The Brethren, he hilariously details the court's struggles with this standard. He details 1960s and 1970s Supreme Court's Movie Day event and various justice tests stemming from watching the films to assess whether they were obscene. Here are what the justices settled on as they watched the films. Justice White: no erect penises, no intercourse, no oral or anal sodomy. For White, no erections and no insertions equaled no obscenity. Justice Brennan: no erections. He was willing to accept penetration as long as the pictures passed what his clerks referred to as the limp D standard. Oral sex was tolerable if there was no erection. Justice Stewart and the famed the Casablanca test: I know it when I see it. In Casablanca, as a Navy lieutenant in World War II and watch officer for his ship, Justice Stewart had seen his men bring back locally produced pornography. He knew the difference between that hardest of hardcore and much of what came to the court. He called it his Casablanca test. This is priceless stuff, that I have the page from the Bob Woodward book here for you to understand what the court was doing. Justice Marshall had just launched into another story when he suddenly stopped. He stared at his watch a moment. It was about 1:50. "My God, I almost forgot," he said in a stricken tone. "It's movie day, we have to get back." Movie day was the humorous highlight of most terms year after year. Several of the justices and most of the clerks went either into a basement storeroom or to one of the larger conference rooms to watch feature films that were exhibits in obscenity cases. Douglas Black, during his years on the court, never went in their view. nothing could be banned. "If I want to go see that film, I should pay my money," Black once said. And he wondered aloud why 9 men sitting in their 70s should make judgments about sexuality. The court was acting as a supreme board of censors, he said. Berger preferred not to go, but the others sat on folding chairs with their clerks, watching such films as I Am Curious projected onto a white wall. During his later years, Harlan watched the films from the first row, a few feet from the screen, able only to make out the general outlines. His clerk or another justice would describe the action. "By Jove," Harlan would exclaim. Clerks frequently mocked Stewart's approach to obscenity, calling out loud in the darkened room, "That's it! That's it! I know it when I see it." Okay, so that movie night approach to figure out the line obviously was not going to work for long, and in 1973 they settled on a new test. This is Miller versus California. Per the Miller test, obscene material may be regulated in terms of criminal law relating to distribution and public display. But private possession of obscenity is protected. Note, child porn is not protected. This came from Stanley versus Georgia. There, the facts were as follows. A warrant was executed for financial crimes. 8mm movies were found. They were deemed obscene, and he was convicted under state law criminalizing possession of obscenity. The Supreme Court reversed. If the First Amendment means anything, it means that a state has no business telling a man, sitting alone in his own house, what books he may read or what films he may watch. Thus, the First and 14th Amendments and right of privacy prohibit the criminalization of private possession. Prosecutions are rare in 21st century, but do occur for sex films with significant violence or other deeply odd sexual behaviors and/or child sex. Let's dive into the Miller tests in more detail now. Whether the average person, applying contemporary community standards, would find that the work, taken as a whole, appeals to the prurient interest. Whether the work depicts or describes, in a patently offensive way, sexual conduct or excretory functions specifically defined by applicable state law. Whether the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. That, then, governs us today as the working standard which protects almost all pornography and removes the Supreme Court from having to have movie nights. So we know that child porn is outside protected speech. But what about simulated or virtual child pornography that is designed to look like kids, but in fact is not kids? This takes us back to 2002. This is Ashcroft versus Free Speech Coalition from 535 U.S., 234 from 2002. Here we had a federal law that banned virtual child pornography. That meant non-realistic depictions of children in pornography. That was the Child Pornography Prevention Act of 1996. It was challenged as violating the First Amendment. Let's first listen to oral arguments of each side defending the federal law and challenging it.
Argument now number 0795, John Ashcroft versus the Free Speech Coalition. Mr. Clement.
Mr. Chief Justice, and may it please the Court. In 1996, Congress updated the child pornography laws to keep pace with technological developments. Congress extended the existing prohibitions on visual depictions of actual children engaged in sexually explicit conduct to cover virtually indistinguishable images and material pandered as child pornography. These provisions are constitutional for the same basic reason that other laws prohibiting child pornography have been upheld. They protect real children from real abuse. They do so in two important ways. First, by preventing the publication and production of materials that are as effective as traditional child pornography in seducing children. And second, by allowing the government to effectively prosecute cases involving traditional forms of child pornography. First, these provisions allow the government to attack material that poses the same risk of enticing children into illicit sexual activities and to pose for child pornography as traditional child pornography. The government has a clear and compelling interest in targeting such material. Indeed, this court in Osborne against Ohio used that rationale to uphold Ohio's prohibition on the possession of child pornography. Second, and equally important, the government has a clear interest in promoting the effective prosecution of the traditional laws against traditional forms of child pornography. The advent and increasing availability of computer technology has allowed individuals to generate computer images that are virtually indistinguishable from traditional photographs. This allows criminal defendants to inject reasonable doubt arguments into virtually every case.
Mr. Chief Justice, and may it please the court. The petitioner's argument, if adopted, would have three radical tragic consequences for First Amendment jurisprudence. First, in the name of protecting children, all visual messages of adolescent sexuality will be forever barred regardless of their scientific, artistic, or educational value. Second, countless visual depictions...
Excuse me, such as what? Such as what? I try to think what great works of art would be taken away from us if we were unable to show minors copulating, or any of the other acts set forth in the definition here. Can you give me a couple of examples?
Certainly in the film area.
Lolita,
Wow. Traffic.
That would be a great. Even the book, the movie Lolita. The book is perfectly okay, right? This only applies to the movie.
That's correct.
Great work of Western art.
It's gotten critical acclaim. The movie Traffic, I think, won an Academy Award. There's the movie Tin Drum.
Besides the movie Lolita, would we be deprived of in order to prevent little children from being exploited?
There's the movie Traffic. There's the movie Tin Drum. There's a whole bunch of there's the Brooke Shields movies that maybe some people don't enjoy, but again, it's there. Blue Lagoon and a series of movies such as that. It would
respect. This is not, the Mona Lisa or Venus de Milo or anything that has lasted more than 30 years.
It could very well affect, I think, painters because the statute. Excuse me.
How about Romeo and Juliet? Interpret one scene that way.
It could, if a movie of Romeo and Juliet were made.
Gee, you've seen a different version of that play than I have.
Well, it depends on how they wanted to portray it. I think that they would have to be prevented from showing or simulated sexual activity because if they are, in fact, to be considered to be underage. And secondly, countless visual depictions of adult sexuality will be prohibited where the adults depicted appear to some unknown censor to be younger than 18. And third, it would open the door to banning other forms of expression simply because the expression could be misused and or abused by a small segment of society.
There you heard the framing of the issues by the lawyers and some court questions. You heard Justice Scalia in particular, in a rather funny exchange, query what if any valuable expression is lost by the law. And now let's see how the court ruled. The court said in a 6-3 ruling, quote, First Amendment freedoms are most in danger when the government seeks to control thought or to justify its laws for that impermissible end. The right to think is the beginning of freedom, and speech must be protected from the government because speech is the beginning of thought. As a general principle, the First Amendment bars the government from dictating what we see or read or speak or hear. The freedom of speech has its limits. It does not embrace certain categories of speech, including defamation, incitement, obscenity, and pornography produced with real children. Thus here, virtual images not involving real children are protected speech, as it does not fit into those categories. Also, as they stated, the government cannot ban speech based on its potential to harm morality. It said, quote, the law prohibits speech despite its serious literary, artistic, political, or scientific value. The statute proscribes the visual depiction of an idea, that of teenagers engaging in sexual activity, that is a fact of modern society and has been a theme in art and literature throughout the ages." End quote. Thus, the Supreme Court held the law was overbroad and unconstitutional. By prohibiting child pornography that does not depict an actual child, the statute goes beyond New York v. Ferber, which distinguished child pornography from other sexually explicit speech because of the state's interest in protecting the children exploited by the production process. As a general rule, pornography can be banned only if obscene, but under Ferber, pornography showing minors can be prescribed whether or not the images are obscene under the definitions set forth in Miller. Ferber recognized that the Miller standard, like all general definitions of what may be banned as obscene, does not reflect the state's particular and more compelling interest in prosecuting those who promote the sexual exploitation of children. The court continued with this as its holding. Here, the government wants to keep speech from children, not to protect them from its content, but to protect them from those who would commit other crimes. The principle, however, remains the same. The government cannot ban speech fit for adults simply because it may fall into the hands of children. The evil in question depends upon the actor's unlawful conduct, conduct defined as criminal quite apart from any link to the speech in question. This establishes that the speech ban is not narrowly drawn. The objective is to prohibit illegal conduct, but this restriction goes well beyond that interest by restricting the speech available to law-abiding adults. The legal impact is important because this was in 2002, decades before the AI and deepfake technology revolution. The case reinforced the principle that content-based restrictions must be judged under strict scrutiny. The court emphasized the protection of fictional and artistic content, and further that fear or discomfort is not a sufficient basis for banning speech. That is a long-standing principle that obviously divides us as a people and the courts. Thus here the law failed to distinguish between actual and virtual harm. As a result, it maintains a high bar for regulating sexual expression not involving actual minors. Now there were dissenters, and it is important in our day and age now to look back at what the dissenters said, as some of it is foreshadowing stuff. Congress has a compelling interest in ensuring the ability to enforce prohibitions of actual child pornography, and we should defer to its findings that rapidly advancing technology soon will make it all but impossible to do so. The First Amendment may protect the video shop owner or film distributor who promotes material as entertaining or acclaimed, regardless of whether the material contains depictions of youthful-looking adult actors engaged in non-obscene but sexually suggestive conduct. The First Amendment does not, however, protect the panderer. Thus, materials promoted as conveying the impression that they depict actual minors engaged in sexually explicit conduct do not escape regulation merely because they might warrant First Amendment protection if promoted in a different manner." End quote. Of course, a quarter-century later, we are in an era of the advanced technology they alluded to with deepfakes and computer AI technology. How will the Ashcroft case fare with AI-created images and deepfake technology today? And how will those fears of the dissent then impact the law 20 years later in our mid-2020s world where online pornography is being regulated by states? We will get to that law soon to see if our three dissenters in Ashcroft have a view that becomes the majority view in the mid-2020s. Let's now shift from virtual material to other modern cultural issues, that is drag. Here we have a Tennessee law restricting adult cabaret performances in any location where non-adults may see it. In this case, Plaintiff was a nonprofit that produces drag-centric plays and performances, and Plaintiff sued saying the law violated the First Amendment. The district court said that the law was vague and aimed at drag performances in public. It issued a preliminary injunction blocking enforcement. Specifically, the court held the law was content-based, not narrowly tailored, and overbroad and likely unconstitutional. The significance of this is that it affirmed drag as expressive conduct. As of 2023, 20 states have enacted legislation aimed at limiting or curtailing drag expression. Given the large number of states with such laws, what are practice pointers if you find yourself in a First Amendment battle here? First, emphasize drag as artistic, political, and symbolic expression. Second, challenge specific statutory language as vague and overbroad, and raise those overbreadth and vagueness objections early. Also, document selective or discriminatory enforcement of such laws. Ultimately, build your defense to position the case within broader free expression doctrines. Now we will go to extreme content and prosections. This is United States versus Extreme Associates from 2005. Here are the facts for you. A 10-count indictment charging the defendants with distributing, either through the mail or over the internet, certain motion pictures that are allegedly obscene. The U.S. Department of Justice press release alleges Extreme Associates produce pornographic videos depicting rape and murder. But the videos depict real sex between people. The violence, including women having their throats slit after being raped, is simulated. The district court held that the indictment had to be dismissed. Why? The statutes violate the privacy rights of Extreme Associates customers under substantive due process per the Fifth Amendment and the right to privacy. The government can no longer rely on the advancement of a moral code, such as preventing consenting adults from entertaining lewd or lascivious thoughts, as a legitimate, let alone a compelling, state interest. Second, we find that, as applied to the particular circumstances of this case, the laws are not narrowly drawn to advance the government's two asserted interests: protecting minors from exposure to obscene materials, and protecting unwitting adults from inadvertent exposure to obscene materials. As such, we find that, as applied to this case, the federal obscenity statutes violate the constitutional guarantees of personal liberty and privacy of consenting adults who wish to view defendants' films in private. But what happened when this went on appeal? The Third Circuit reversed. Here's what it said. The Supreme Court has decided that the federal statutes regulating the distribution of obscenity do not violate any constitutional right to privacy. For district and appellate courts in our judicial system, such a determination dictates the result in analogous cases unless and until the Supreme Court expressly overrules the substance of its decision. Thus, there was no substantive due process right and no First Amendment violation. The Internet is a channel of commerce covered by the federal statutes regulating the distribution of obscenity. Extreme Associates was indicted for engaging in commercial transactions that its own brief on appeal describes as Internet commerce. Now we can go from hardcore sexual content to Playboy, and I guess you would call it tamer content in comparison, and here we see how it collides with FCC regulations and the airways. This brings us back to the Supreme Court in 2000. Here are the facts. The FCC required cable companies to block sexually explicit channels during certain hours. Specifically, it required that cable operators, providing channels primarily dedicated to sexually oriented programming, either to fully scramble or otherwise fully block those channels, or to broadcast those channels during the safe harbor hours of 10 p.m. to 6 a.m. Those are defined times when young children were unlikely to be watching. Playboy challenged the statute as a violation of free speech and expression rights under the First Amendment. The issue as framed was as follows. Was this law the least restrictive means to block the transmission of cable television channels primarily dedicated to sexually oriented programming, such that it does not violate the First Amendment? The Supreme Court ruled in favor of Playboy, albeit barely in a 5-4 decision. It held that the government must use the least restrictive means to regulate content, and that adults have a right to receive sexually explicit material. Thus, the court held that government failed to show that the law was the least restrictive means to further its interests, and thus that requiring cable television operators to fully scramble or limit time when sexually oriented programming was transmitted violated the First Amendment's free speech guarantee. But we had dissenters. Here is what they said. Justice Scalia said that his views were that the law can be upheld by finding that it regulates the business of obscenity. As he wrote, "It is not only children who can be protected from occasional uninvited exposure to what Apelli calls adult-oriented programming. We can all be." End quote. Justice Breyer wrote that the law was in fact supported by a compelling state interest and was narrowly tailored. The government did all it had to, in other words. Because the material was so sexually explicit, the government satisfied burden standards in regulation, he believed. He wrote, quote, "This legislative objective is perfectly legitimate. Where over 28 million school-aged children have both parents or their only parent in the workforce, where at least 5 million children are left alone at home without supervision each week, and where children may spend afternoons and evenings watching television outside of the home with friends. The law offers independent protection for a large number of families." End quote. This case involves a Texas law that required pornographic websites to use an age verification system to limit access to pornography by minors. Texas is one of at least 20 states with such laws. The Free Speech Coalition sued, saying it violated the First Amendment. The district court held that the age verification system violated adults' rights to access constitutionally protected material. The Fifth Circuit held that the age verification standard was fine, using rational basis review. The question then is, does rational basis apply to the Texas law, or is it subject to strict scrutiny? Given ubiquitous access via technology in our current era, the prior precedents and brick-and-mortar analogies may not be dispositive. Let's again listen quickly to the framing of the arguments before the court, before we get to the court's important ruling.
We will hear argument this morning in Case 23-1122, Free Speech Coalition versus Paxton. Mr. Schaefer.
Thank you, Mr. Chief Justice, and may it please the court. In this case, a Fifth Circuit majority held that mere rational basis review, the most lax form of judicial scrutiny, applies to a Texas law that burdens constitutionally protected speech based on its content, specifically by imposing an age verification barrier before anyone can access a sexually themed website. That aberrant holding defies this court's consistent precedent, including its Ashcroft decision, as Judge Higginbotham well explained in his dissent. This court should begin by confirming that strict scrutiny continues to apply to any such content-based burden on websites and their adult users. Notably, Texas's law is even more problematic than its failed federal predecessors. It applies to entire websites, depending on whether 1/3 of their content is deemed inappropriate for minors. It also brands websites with stigmatizing, unscientific so-called health warnings that, despite being enjoined, evidence Texas's intention to deter adults, even assuming they've cleared the age verification hurdle, from accessing protected speech. To abandon strict scrutiny here, Your Honors, could open the door to an emerging wave of regulations that imperil free speech online. From there, this court can readily restore the preliminary injunction given petitioners' likelihood of success under strict scrutiny. The district court found that this law's age verification provisions are wildly under-inclusive and unduly chilling. At the same time, content filtering today affords at least one alternative that is both less restrictive and more efficacious. Ashcroft teaches that a preliminary injunction should stand in precisely these circumstances. That result, Your Honors, does not denigrate government's compelling interest in protecting children, nor does it prevent Texas from trying to carry its burden between now and final judgment or from enacting a new and better tailored law. Rather, reinstating the preliminary injunction would simply maintain fidelity to First Amendment rights and precedents while litigation proceeds. I welcome the court's questions.
Can age verification systems ever be found constitutional?
Justice Thomas, I think government should start with content filtering as a less restrictive alternative.
But can age verification ever be constitutional?
I don't think the court needs to close the door to that here, but it would need to be tailored age verification of the sort that the amici supporting Texas are advocating, which is different from what Texas's law permits.
And what would that look like?
I think, Your Honor, what you have from the amici is that there are ways of verifying age short of identifying the individual, short of the transactional data that Texas would require be provided. And so you would have less identification of the individual. You would have privacy protections that are maximally assured by the law. You would have private rights of enforcement that you do not have here. Everything depends upon the Attorney General, who's avowedly hostile to these websites and to their users. And last, Justice Thomas, you should have confidentiality that is legally assured, and the state should be providing assurance that it will not misuse the information that is being collected pursuant to the state mandate.
Mr. Chief Justice, and may it please the court, petitioners don't dispute that their websites are not meant for children, that they harm children, and that children are watching. The court faced the same situation with brick and mortar stores and applied rational basis to a law limiting adult content to adults. This case is the digital version of Ginsburg. 3 cases prove the point. Ginsburg itself applies rational basis where a store can only avoid liability by making, quote, a reasonable bona fide attempt to ascertain the true age of customers. Sable applies rational basis where speakers must separate their audience before speaking a message obscene to some, but not all. And in Ashcroft 2, the court didn't apply rational basis because Congress, limited by 1990s technology, went well beyond Ginsburg and Sable. To understand Ashcroft 2, you have to understand Ashcroft 1 and look how the court in Ashcroft 1 treated Sable. Age verification today, however, is simple, safe, and common, including non-identifying means. Petitioners' view of Texas's law is contrary to Texas's view of Texas's law and the Fifth Circuit's view of Texas's law. Regardless, if strict scrutiny applies here, Texas would have to satisfy strict scrutiny to keep kids out of strip clubs. This court's cases do not require that. Neither do history, tradition, or common sense. In all events, even if heightened scrutiny applies, Texas easily satisfies it, especially facially. We've tried content filtering for decades, and the problem has only gotten worse. I welcome the court's questions.
The Ginsburg sounds simple, but in the tech cases we've had recently, we're talking about hundreds of millions of members to certain sites, billions of visits, multi-billions, if not trillions of exchanges. How do we determine what burden, and assuming we agree with you, and I think most people do, that kids are to be protected, how much of a burden is permissible on adults' First Amendment rights?
Well, so long as Ginsburg is part of this court's canon, any burden less than the burden at issue in Ginsburg necessarily must be okay.
So how does that translate in a world in which you're not talking about one-on-one transactions, but billions of transactions?
Yeah, that cuts in favor of Texas. One of the important parts of modern age verification technology is that you can do it without identification at all. The Fifth Circuit was clear that under Texas law, biometric scanning is okay. In other words, there's no ID or anything like that. It's just a face scan. If that's too much, I would point the court to the brief of the Age Verification Providers Association. You can do a hand scan. There's all sorts of things you do that have no identifying information.
You're talking.
So there you had the arguments, and here is what the court held. Texas' age verification system is subject to intermediate scrutiny, which means it can be regulated without finding the least restrictive way to impinge collaterally on adults' right of access. Remember from earlier in our program, laws that only incidentally burden protected speech are subject to intermediate scrutiny. That power includes the power to require proof of age before an individual can access such speech. It follows that no person, adult or child, has a First Amendment right to access such speech without first submitting proof of age. Thus, in regulating online pornography and its massive scope and ease of access for minors by demanding age proof of all who want to access it, Texas does of course interfere with the free access of adults who must also prove their age. That incidental burden on adults does not matter, as Texas may do it. So this case is very significant in 2025, in that it has cut back on the Ashcroft strict scrutiny world we saw. And the majority here expressly discussed the change in technology over the last quarter century with smartphones in the hands of apparently 95% of all children and ubiquitous online porn. Here is what the three dissenters said. Texas may be able to survive strict scrutiny, but in all events the test should be strict scrutiny. That is, the goal of protecting minors from pornography allows regulation, but a state should so with utmost care to not regulate adult access to lawful material. The dissenters disagreed with walking back from a history of content-based laws being subjected to strict scrutiny now into an era of intermediate scrutiny. The dissenters wanted to make sure that states that regulate minor access to sexual material do so in a way that always ensures it imposes the least restrictive measures possible. Here's what they said, quote, "But what if Texas could do better? What if Texas could achieve its interest without so interfering with adults' constitutionally protected rights in viewing the speech?" That is the ultimate question on which the court and I disagree. The majority says that Texas may enforce its statute regardless, because only intermediate scrutiny applies, and that test does not ask whether a state has adopted the least speech-restrictive means available. I disagree, based on conventional First Amendment rules, and the way we have consistently applied them in this very context. The state should be foreclosed from restricting adults' access to protected speech if that is not in fact necessary." End quote. So we have seen the huge fracture lines in the court on regulating sexual material under the First Amendment, especially as it reaches children in various manners. We saw shifting concepts of obscenity also, with Justice Scalia saying Playboy's material could simply be regulated as obscenity. We have one huge unanswered question, though, and that is, can pure literary works be obscene? This is the Red Rose case of fictional child molestation writings. Defendant owned a publicly accessible website. The website included areas and content available to the public, consisting primarily of excerpts from extremely explicit and graphic stories describing the sexual abuse, rape, torture, and murder of children. The website advertised that additional areas and content were available for those who purchased a membership to the website and became a member of the site. The defendant pled guilty and got 5 years probation. Thus, there was no ultimate resolution by Supreme Court of whether state criminal laws can outlaw fictional obscenity writings or whether the First Amendment allows such writings to be protected. Was this case an example of prosecuting over fantasy literature? Or was his prosecution worthy because the material may incite pedophiles to exploit minors? That question is a big one that the law has unanswered today, and it is a question that will be tested in coming years with deepfakes, AI, and computer creations, visual and literary, online. Will Ashcroft's rule continue to cast a shadow that protects such materials, or will Ashcroft get revisited in this context as we saw it be revisited in the Texas case? Remember, it was a 6-3 ruling, and the conservatives were the dissenters, which may portend today a rule reversal afoot, especially as new technology intersects with these issues, as we saw animating today's 6-3 split the other way. Let's now turn to sex and speech in the context of where prostitution meets pornography. Here is the basic background to understand how this got litigated. Adult actors get paid to act in sex films, of course. And the state of California, at some point through one of their prosecutors, decided that since the adult actors were being paid to have sex, they were actually engaged in prostitution. Here is the case and its facts then. An adult film producer was charged under pimping and procurement laws relating to paying 5 women to act for a non-obscene pornographic film. He was then indicted under pimping, pandering laws. He argued the payment of monies was for acting, not for sexual arousal or gratification of the payer or payee. Furthermore, defendant argued that he did not participate in the conduct. This then is the case of People v. Freeman that went to the California Supreme Court in 1988. Let's see what the Supreme Court did with this theory. It held that the anti-pimping and pandering laws were not intended to apply to adult movies where the paid person is acting, and hence all are engaged in protected free expression. Quote, regardless of our view of the social utility of this particular motion picture, our analysis must begin with the premise that a non-obscene motion picture is protected by the guarantee of free expression found in the First Amendment. End quote. Thus, even if the defendant's conduct could somehow be found to come within the definition of prostitution literally, the application of the pandering statute to the hiring of actors to perform in the production of a non-obscene motion picture would impinge unconstitutionally upon First Amendment values. Accordingly, the attempt to regulate pornography by skirting obscenity standards will not work. Finally, what about incest between consenting adults? This is from California also, in People v. McAvoy from 2013. Here are the facts. Defendant was prosecuted under Penal Code 285 that states, quote, persons being within the degrees of consanguinity within which marriages are declared by law to be incestuous and void, who intermarry with each other, or who being 14 years of age or older, commit fornication or adultery with each other are punishable by imprisonment in the state prison. End quote. Defendant claimed that the sexual encounter between himself and his sister was consensual, and that consensual sexual activity, even if between siblings, is a protected liberty interest. Not so, the Supreme Court held. There is no protected liberty interest that denies the state the ability to prohibit sexual relationships of the kind outlawed by incest laws. California's interests in protecting the integrity of the family unit and protecting against inbreeding are sufficiently important to justify Section 285's incest prohibition. Thus, in any given non-consanguineous relationship, the rate of severe abnormalities in offspring is estimated at 2 to 3%. For offspring of first-cousin incestuous relationships, the risk increases to approximately 4 to 7%, while children of siblings or a parent-child coupling have a risk between 31 and 44%. We looked at where sex intersects with the law heavily as it relates to First Amendment issues. We saw a history of Supreme Court struggles to confront sex, the law, and the First Amendment. Content-based restrictions and expression rights, strict scrutiny analysis, intermediate scrutiny, least restrictive means tests were all explored. Specifically, we looked at obscenity and First Amendment from the I know it when I see it standard to the Miller test today. We looked at virtual child pornography and Supreme Court rulings, pondering the viability of the old Ashcroft test in the modern deepfake and AI age. We saw that whereas in the late 1990s, online pornography restrictions in the Ashcroft case were subject to strict scrutiny, today in the mid and late 2020s, the court saw the technology world had shifted in a way that made strict scrutiny no longer appropriate to apply to states. Curiously, we saw the 5-3 split in Ashcroft that went to the liberals, now in the Texas case of age verification, the same 6. 3 split occurred, but it went to the conservatives. Thus, we now have intermediate scrutiny on these age verification laws. That is a big sea change in First Amendment sex law, because it allows the state broader power too in the legitimate act of regulating to impinge upon adults' First Amendment rights in this area. Sex content speech, in other words, is dropping into a lesser protected category. We saw state limits on drag performances and the First Amendment at work, and we saw the line between pornography and prostitution, along with incest and state regulations. But we are still left with an open question that matters in the AI age. Can pure literary works be obscene? The same technology concerns that animated the Texas case animate the creation of literary obscenity with AI and deepfake technology becoming readily available and easily to access and use. Will we be able to use an AI system to create literary obscenity and still find First Amendment protection? Does it matter if it is human created or AI created? These are questions that will start testing the First Amendment in the sex space even more as technology advances. No doubt there are more First Amendment sex law trials to follow, so stay tuned, stay curious, and as ever, email me any questions. Thank you.